Yes, you hi, welcome viewers, and this is the barrister, and today we are to talk about administrative law, administrative authorities basically, and administrative law basically. Uh, it is where we deal with public offices as far as administration is concerned. But before we go any further, I would like you to subscribe to the channel. Yes, make sure you subscribe to the channel, then we proceed. Administrative law one, basically for those in year two, basically, I want you to understand that it is the branch of public law that regulates the power, the function, duties, and procedures of public authorities and governance, plus the government agencies. So it's where the government agencies exercise their duties in a smooth way so that there is no what we call the procedural defects, uh, where we should ensure that there is no the ultra bias, the use of uh, power beyond your limit, uh, and many more. So, by definition, Sir Ivor Jennings, in the law relating to administration, he defined administrative law as the for him he defined administrative law that's where it determines the organization, power, duties of administrative authorities. So for him, he defined it like this, that it determines or it concentrates on the organization's power, duties of the administrative authorities. Now, when we want to talk about the organizations, you have to understand the organizations, government organizations. We want to talk about um, the authorities like KCCA, Kampala City Council Authority, and very many more. But when you look at the definition of the Ayebare in the Ayebare's book, it is an author, a Ghanaian author. So for him, he talked about that administrative law is concerned with the control of administrative authorities to ensure that they act lawfully. So that um, administrative law is basically to ensure that the administrative authorities acts lawfully, nothing else. So when you talk about the sources of administrative law, you have to understand that we have the constitution as the grand norm. When where we want or when we are to talk about the sources of law here, you have to understand that the constitution of Ghana must be key, must be at first, then followed by the acts of parliament, judicial precedents, so commonly known as the cases or case laws. Then we have the common law. Yeah, common law, we have the principle of natural justice. In administrative law, we shall basically see, we shall put much of the emphasis on the natural justice. Why? Because natural justice brings the principles on how someone must be uh, someone must be uh, uh, put in a situation that he or she deserves uh, by giving him or her rights to act or rights in very many ways. Now, uh, the administrative law, why was it basically uh, relied on? One was to promote rule of law, as we're going to say, rule of law, and again to promote individual justice, to control abuse of power, that is ultra vires. You find the administrators who act ultra vires, um, they have where they have where they can stop, but they are acting as if they own the whole world out of us, beyond their jurisdiction or beyond their limits. So that is acting out of us. Um, Again, there is what we call provide legal remedies. Provide legal remedies, that is when there is a remedy like statutory, a remedy like injunction, and very many remedies, as we are going to see as we proceed in this course unit. But let's dive now and see on what we call the rule of law. Rule of law, you basically know that person known as uh, uh, Von Dicey. Von Dicey, basically, for those who studied constitutional law, you understand Von Dicey. Rule of law basically portrays that no one is above the law. Yes, we are all under the law. We are treated similar by the law. We are just treated to be similar by the law. The law cannot treat someone well and treat another person just unfair. Now, one day say, according to the study of the law, of the Constitution, uh, for him, he talked about the rule of law, and he said that the rule of law must consist of the three aspects where he talked about the supremacy of the law, that no person should be punished except accordance with the law. The law says this, and for you are punishing the person otherwise. So he condemned that. Then he talked about the equality before the law, that we are all equal, we are all treated equally by the law. He went ahead, talked about the protection of rights through ordinary courts. When you reach the court, then the court must treat you as the way you are. You remember the case of um, this person who killed young children at school, so-called Okello. Yes, Okello versus Uganda, the recent case, you understand. So, however much he did what he did, yes, we know the presumption of innocence, that they treat you as if you are not guilty until you are presumed, or until you presume otherwise. But they give you room to exercise. When you say, I not guilty, then they will provide evidence as you provide the same. Then when they provide evidence that really puts you to the crime scene, then you are convicted. Um, in the case of Tinyefuza versus Attorney General, it is a very good case that emphasizes what we call the protection of human rights in court. And the recent case of Dr. Kiza Besigye also talks about uh, the, the human rights. And Professor Kanyihamba, he also, in the case of Dr. Kiza Besigye versus uh, Yoweri Museveni, also talks about um, the rule of law to be key, that where there is no rule of law, then there is nothing should be relied on. That where there is where you find that rule of law to some point um, is violated, then there is nothing that you can proceed where there is the violation of the rule of law. Now, the constitutional provisions, Article 20, that provides for the fundamental human rights, that rights that are inherent, whereby nobody should take over your rights. You are just given those rights, and they are just controlled by the state. I mean, they are like the state is the one to control that, but the state is not the one giving you the right, but it is controlled. In any violation of the right, then the state must be would liable to explain. Now, Article 42 of the Constitution of Uganda that provides right to lawful, reasonable, and procedural fair administrative treatment. The moment you go to the administrative office or court, the court must receive you and treat you fairly and just. That's why I gave you the scenario of the case of Okello, that even if you did something that is reasonable sin that you did it, but the court must give you room to exercise your rights. Now, Article 28 clearly talks about the fair hearing. When you're going to the court, when you went to the court, then the court must give you what we call fair trial, fair hearing. That's where we shall deeply talks about the Article 28 uh, when we to talk about natural justice. Um, Article 126 talks about the judicial power exercise in conformity with the law. The judiciary, lawyers, and judges must exercise their duties but in conformity with the Constitution powers. The Constitution says this: the judge must not rely on his own provisions, must tackle the provisions of the land or of the Constitution. Article 128 that talks about the independence of judiciary. Yes, where the judiciary is independent, then uh, it's ready or it is okay to give a fair trial. But when it is not independent, that's where you find they are giving unfair treatments. Thank you for watching. Thank you for listening. We shall go on with administrative law, basically to other topics, and I shall you to you all. Thank you for watching.